very warm welcome to lesson number 46 in our 50-part series on the law of evidence. In today's lesson, we will be discussing the concept of privileged communications, which we find within the chapter relating to witnesses. So chapter 9, that extends from section 118 to 134, talks about witnesses and what witnesses can say, what they cannot say. It tells you several provisions about their competence and about what they can say. Most importantly, it tells you about some things that they cannot say because those communications are privileged. What that means is that it cannot be brought to the fore. It is protected by privilege. It is protected by the privilege of confidentiality. Let's have a look at some of these provisions as we advance into this lesson. Like I said, when you're looking at chapter 9, which deals with witnesses, there are a few questions that you should be able to answer about a witness. Now, who can be a witness? What is it that the witness can say? And what is the manner in which he can say it, right? So when you're talking about witnesses in general, when you're looking at the entire Indian Evidence Act and you're looking at oral evidence, this essentially is what you need to know. Who is the person who's competent to be a witness? What can he say? And how should he say it? That's simply what there is to witnesses. And you find many of your answers in the chapters 9 and 10. Okay, let's look at these points one by one. First, what can be said? Okay, with regard to oral evidence or any kind of evidence, what can be said is a subject matter of the facts, and those should be relevant facts. And therefore, what is being said has to be a relevant fact as the provisions between 5 and 55. If a fact has been declared to be relevant, you can speak of it, okay? And also when you look at section 59, it tells you that in oral evidence, you cannot speak about the contents of a document or of the contents of an electronic record. So that pretty much tells you as to what can be said by a witness. Next, we look at who is competent to be a witness. You see, if you remember, there was section 60, which said that oral evidence must be direct, which means that the person who is, competent to say it, or the person who is permitted to say it, is the person who has either seen it himself or has heard it himself. If it is an opinion, it is by the person who holds that opinion. So that's the first point you need to know about the competency. Okay. Also, when you look at chapter 9, you will see as to who can be a witness, and we will see some of those provisions now. So they also in a way deal with the competency of a witness. It will also tell you who cannot be a witness, and we shall see some of those provisions also. And we'll talk about what cannot be said. Like I said, we will be emphasizing on privileged communications as being those things which cannot be said before the court. Okay. Now, how can it be said? You see, witnesses speak through the process of their examination. Okay, so the witness goes to the court and then he is examined. Okay, and that's what you find in chapter 10, which deals with the examination of witnesses. You will find that they have an examination in chief, a cross-examination, a re-examination, and that we will see in the later video. And there are some rules that they have to follow about how they will be examined. So you will find that when you look at chapter 10, that starts from section 135 and goes up to section 166. It's very simple, very straightforward. You will come to know as to all of what these things are. You will find that there are certain rules that have to be followed. And once you know this, you know as to how witnesses will present their points before the court. So what does the witness do when he comes to the court and speaks? Well, that action is called testifying. So when a witness comes to the court and he speaks, he is testifying. Who can testify? According to section 118, every person is competent to testify, right? It can be a person who is extremely young. It can be a 2-year-old person. It can be a very old person. It can be a 102-year-old person. It can be perhaps a person who's suffering from a mental ailment, right? Even he can say it. But what is the requirement? The requirement is that it should be a person who is able to understand the question that is put to him. So it should be a person who can understand the questions. Second, he should be able to give rational answers. So let us say there is a person who is medically mentally retarded, but he can understand the questions and he can give rational answers. Despite that, he remains competent. However, if because of certain factors, whatever those factors might be, for example, young age, old age, disease, or whatever, if because of these one cannot understand the question or give rational answers, then this person is not competent. Okay? So, competence is not about whether a person is in a certain state. It is about whether that person can comprehend the questions and give rational answers or not. When you look at the explanation, as you can see, a lunatic. Now, a lunatic is a kind of person of unsound mind who has what is known as lucid intervals, which means sometimes he's okay and sometimes he's not. Okay? So, when he is not prevented by his lunacy, which means when he's okay, and if he can understand the questions and if he can give rational answers, then he is not incompetent. He can go ahead and testify. Okay. We've already seen section 119, right? We saw section 119 in the lesson where we saw section 63. You see, section 119 talks about dumb witnesses, witnesses who cannot speak, right? So somebody has come to the court and he wishes to testify. Section 119 says that a person who cannot speak can either use signs or can write it down, and then this written testimony will qualify as oral evidence. That's what you find in section 119. Okay. Now let's go further and see some more important points. Let's talk about spouses. You see, it says here that in all civil proceedings, the parties to the suit and the husband or wife of any party shall be competent witnesses. So here it talks about civil. Next it goes on to talk about criminal. In criminal proceedings against any person, the husband or wife of such person shall be a competent witness. You know why it's not spoken about the parties in a criminal proceeding? Because then you're talking about the husband or wife of the public prosecutor, who is the other party. So we don't need to talk about the husband or wife of the public prosecutor. We only need to see the husband or wife of the accused. And in a civil proceeding, of course, you have A and B, right? So if A and B are there, then husband, wife, his husband or wife, or her husband, wife, whatever, these people are competent to testify. So section 120 is very simple. It talks about the fact that spouses can testify. Okay, they are competent witnesses. Let us go a little further and see as to why this is important. Let's have a look at section 136, not of the Evidence Act, but of the IPC. Okay. The word harbor is defined in section 52A of the IPC, but I'll not get into the definition. Harbor, well, harbor basically means that you have given some shelter and you've given some protection to somebody else. That's harboring. And as you know, when you harbor a person who's done wrong, then you do wrong by doing so. You will find that there's 136, there are more such related sections. In fact, if you look at 212, that also will help you in getting to the point that I wish to make to you right now. So basically what section 136 says is, you needn't waste your time reading it. 136 says that, let us say there is an officer of the armed forces, maybe the army, navy or air force, and he deserts the army and leaves. So basically you know that officers cannot leave their post, so he's deserted. Now, if somebody harbors, so whoever harbors this person, so there's an officer who has deserted. If this person is harbored by somebody, then that person could be punished for a period extending to 2 years. That's not the point that I wish to make. What I want to draw your attention towards is this exception here. It says that this provision does not extend to the case when the harbor is given by the wife to the husband. Okay, which means that, let us say a person has deserted and now his wife protects him and keeps him. This is not an offense. Do you realize that there's a certain sentiment that the law accepts? The law here believes that while a person who has deserted should not be harbored. There is a responsibility that spouses have towards each other, and if someone discharges that responsibility, the law does not interfere with it. You see, the law is keeping away from the sanctity of the matrimonial tie, right? You will find a similar thing in section 212 as well, which deals with harboring. And again, whenever the harboring is done by a spouse, so there it says husband or wife, here it says only wife, because as of when this law was made, then you did not have women in the army, right, or the air force. Okay, so the point being that spouses can harbor each other without attracting penalty, which is otherwise given under these sections of the IPC. In the same vein, you will find section 122. That is an example of what we were studying, which is of privileged communication. Which means that if there has been a communication during marriage between two people, that is between spouses, you see, that is made in a certain amount of trust. In marriage, people communicate to each other a little extensively, not often taking care of their own safety, not often being careful about what they've said. And now, if somebody is to bring this communication to the court and bring that to the open, then perhaps it is an injustice to the trust and to the very institution of marriage. And you can see that the law tries hard, at least in India and in several such provisions, you will find that there is an attempt to preserve the sanctity of marriage, to preserve marriage, right? So, a communication which has been made in the trust of the matrimonial tie must not be broken even if things get sour tomorrow, right? So you see, it says no person who is or has been married shall be compelled to disclose any communication, which means that let us say you have spouses A and B, or let's make it husband and wife, H and W. You have husband and you have wife. No person who is or has been married, which means this applies even if they have been divorced, okay? But the communication was made during the marriage. So whether they are married today or not does not matter, but yeah, the communication was made during marriage. No person who is or has been married shall be compelled. That means they shall not be compelled to make any communication, to disclose any communication, nor shall he be permitted. So neither can you compel him, nor will you permit him to disclose any such communication unless the other person consents. So in no case can you compel. Let's say, for example, can you force the husband to say what was discussed during the marriage? Let's say the wife had told him that she had committed the murder of a person A when she was 15 years old. Maybe she told him this, okay? Now, can you force the husband to declare this? No, you can't compel him. Also, you cannot even permit him to say it unless the wife consents. Which means if the wife does not consent, okay, the wife has not said that okay, you can go ahead and say it. If the wife has not consented, then the husband is not even permitted to disclose it. So he can neither be compelled nor is he permitted to disclose it, okay? But let us say, does that mean, let us say husband and wife have not a great matrimonial tie, because you know that the matrimonial tie is not always one that is pleasant. So let us say the husband and wife have had serious fights, they've physically abused and hurt each other. Still, does that mean that communications cannot be brought to the fore? Do you still have to offer privilege? Can the wife not speak about the husband? Can the husband not speak about the wife? Well, they can. And as you can see here, the exception. Except in suits between the married persons. So if the dispute is between them, right? Or in proceedings in which one is prosecuted for a crime committed against the other. So suits means civil, proceedings for prosecution is in the criminal. Okay? So let us say if a man, let's say there's a person, a man is in a dispute with, say, another person, man 2. Now you have various kinds of witnesses. Maybe someone calls his wife to the dais. Now, the judge cannot tell the wife to disclose to the court what her husband had told her. So if her husband had trusted her and told her something, she cannot be forced, and she will not even be permitted unless he consents, right? The exception being, the exception is if the dispute, instead of being with someone else, the dispute is between the couple itself. So if the dispute lies between these two people, well, then there is no privileged communication. Both can say whatever they have to. So essentially, the principle that underlies Section 122 is that spouses are expected to keep each other's secrets, and that keeping secrets between each other in marriage is more important than really disclosing material before the court, right? So ordinarily, people are required to answer any question put to them. In fact, they can be compelled. If you look at Section 132 and Section 147, you realize that a witness can actually be compelled to make a statement. However, you can't compel a witness to say something that was said to him or her in the confidence of marriage. Okay, so secrets must be kept, and the law appreciates this fact that secrets sometimes have to be kept. You must have heard of the Official Secrets Act, and that should tell you that there are some things which are official secrets. If some pieces of information are brought to the fore, then it could create problems, right? So if someone is aware of some of the evidence relating to the affairs of the state, there are some facts that are not published, there are some official records that are not published, but they're affairs of the state. And if an officer feels that if he brings this to the notice of the world, it would cause a problem, then you see, no public officer shall be compelled to disclose such kind of communication which was made to him in official confidence. So you're honoring official secrets, or you can say sensitive data relating to official matters of the state. Now, when we are talking about secrets, then we also talk about professional secrets, and we talk about our very own profession, which is the relationship between the lawyer and the client. And we know that there is a relationship of great trust between the lawyer and the client, and the client often tells lawyers some things that he would not have told anyone else. Let us look at how this is dealt with in Section 126 of the Act. Alright, so you can pause the video and read this part once if you already haven't. Essentially, what you have here is that, let's say there is a barrister, attorney, pleader, or vakil. Let me just simply call him vakil for the ease of simplicity. He is not permitted to disclose, right? He is not permitted because the communication is privileged. He is not permitted to disclose any communication that was made with him during the course of his employment. During the course and the purpose of his employment. Just pay attention to these words here. During the course or for the purpose of his employment. Okay? Or he is not even permitted to disclose any of the documents, neither the conditions nor the contents of any documents with which he has again become acquainted, again during the course and for the purpose of his professional employment. Okay. Also, he is not permitted to disclose any of the advice that he has given to his client during the course of this employment. So he is not permitted to give any information of the communications made, the documents, or the advice rendered. Notice here that it does not use the word compelled, which means that even if the vakil wants to, okay, the court will not allow him unless the client himself expressly says, okay, you can go ahead and tell the court. Okay, So this is protecting the confidentiality of the relationship between the lawyer and the client. However, this can be misused, and so let's look a little further into this this provision. It should not be a communication that is made in furtherance of an illegal purpose. Let me tell you the difference between two things. Case number one, A, who is a client, goes to a Vakil V and he says, Vakil Saab, I have committed murder. I need you to help me out. So I've committed the murder of B. I need you to help me out. Please save me. Now this thing which he has told V, the Vakil, this is protected by 126. Okay. However, if A goes to the Vakil and A says, you know what, there is this man B, I really hate him. I want to murder him. Okay. I want you to help me out with the law so that, I can kill him in a way that I don't get trapped. This is a communication that is made in furtherance of an illegal purpose. That means he's taking advice in order to commit it. This is not protected by 126. Therefore, now this thing which was told to him here, that he wants to commit the murder, well, that is something that this can be brought to the notice of the court, because it is not protected by section 126, as this is in furtherance of an illegal purpose. Have a look now at the second proviso. Let us say A comes to the Vakil, the lawyer, on maybe the 20th of January 2020. Okay. And he tells the lawyer that, sir, on the 10th of January 2020, I had committed the murder of B. Now, when he comes and tells this to the lawyer, it is protected by section 126. Now, let us say they continue, they have a lot of talks and it goes on. And then the lawyer realizes that A has also committed the murder of C on the 25th of January. Okay. Now, look at the proviso. Any fact observed by any lawyer in the course of his employment showing that a crime or fraud has been committed since the commencement of employment, which means it commenced on the 20th. This was done on the 25th. This again is not protected by 126, right? Again, this is something that is observed by him. It is not something that has been told to him. It has been observed by him. If he has observed it, then this thing is not protected by 126. This little final part here, I'll choose not to explain this to you, and instead I'll ask you a question. It talks about it is immaterial whether the attention of any such lawyer was or was not directed to such fact. I want to ask you, what is this such fact referring to? What is the fact that is being spoken of in here, right? Just let me know in the comment section. Okay. And like with marriage, we saw in 122 that even after the marriage is over, the communication that was made during the marriage continues to remain privileged. Likewise, the obligation remains even after the employment has ended.